It's a great pleasure and a privilege for me to introduce Her Excellency the Honourable Margaret Beazley, Officer of the Order of Australia, Queen's Counsel and Governor of the State of New South Wales in the Commonwealth of Australia, to deliver the 2019 Supreme Court of Queensland Oration. I looked up the correct style and title, although I think Her Excellency is the vice-regal representative least likely to be concerned about it. I welcome everybody to the Banco Court tonight, judicial colleagues, fellow practitioners and friends, and in particular, falling into both the last two categories, Her Excellency's husband, Mr. Dennis Wilson. The oration is being streamed to Townsville this evening, so I welcome those watching there too. As I'm sure you all know, in a move which has won the enthusiasm of all, Her Excellency was appointed the 39th Governor of New South Wales from the 2nd of May 2019. She has, so to speak, hit the ground running since then with a series of engagements, which makes us all the more grateful that she's nonetheless adhered to the commitment to speak to us tonight on the question, 100 years after Federation, is it different? Now, can I chip in straight away on this topic? Of course it is. A century ago, I wouldn't have been introducing a woman with a long and distinguished career at the bar, a Queen's Counsel, as Her Excellency became in 1989, because New South Wales only passed its legislation to enable women to be admitted in 1918. More than a decade after Queensland, but that's another issue. 100 years ago, I wouldn't have been introducing the first woman to be appointed to sit exclusively as a member of the Federal Court, as Her Excellency was in 1993. And I'll digress a little here because Justice Virginia Bell of the High Court told rather a nice story the other night at a dinner I attended in honour of Her Excellency about how the administrative staff of the Federal Court, on Her Excellency's appointment as Governor, had combined to buy a gift with a card because of their great affection for her, even though she left that court in 1996 to become the first woman appointed to the New South Wales Court of Appeal, which, as Justice Bell pointed out, says a great deal about the sort of person she is. And to go back to the difference this century has made, in 2013, Her Excellency became the first woman to serve as President of the New South Wales Court of Appeal, filling that role with great distinction both as a jurist and as an accomplished people manager. Things plainly are very different after 100 years for me to have the pleasure of introducing a woman with so many firsts, let alone a woman in a vice-regal capacity. But in fact, I should tell you, Her Excellency is going to limit the scope of the subject somewhat by talking about specific topics which I don't think include gender issues. With considerable anticipation, I invite Her Excellency to deliver the oration.
Thank you, Chief Justice, and that's the most formal that I'll be tonight. I look around the audience and I see so many friends, so thank you very much for coming. My current line is, the trouble with being first often is that somewhere along the line you have to end up being second. And of course I was, to Margaret McMurdo, who was, I think, the first female president of a Court of Appeal throughout the country, and served with extraordinary distinction, legal distinction and extraordinary dignity during her entire time. So just quite wonderful. And then, of course, in my current position, there's the iconic Dame Murray Bashir, who was the first female governor in New South Wales. And indeed, even then, I'm the second lawyer, third non-lawyer, but third non-military person in New South Wales, but the second lawyer. But that's not what I'm here to talk about tonight, and I'm very, very grateful for your attendance. I thought I'd just talk about what was happening just after Federation in Australia and what we might be talking about now in the legal sphere. And I'm sure I have many historical devotees in the audience, but you must understand this is just a sort of little butterfly flit across a number of issues. But when the Commonwealth of Australia came into being on the 1st of January 1901, Alfred Deakin became Australia's first law officer. He held the portfolio of Attorney General from Federation until the 24th of February 1903, when he became Prime Minister. And then as Attorney General, Deakin was succeeded by James Drake, about whom I don't think we know very much at all, and then Sir Isaac Isaacs. Deakin was an extraordinarily humble man. He was the only Prime Minister to reject the title of Right Honourable, to refuse honorary degrees from Oxford and from Cambridge, and to reject membership of the Privy Council. And he was otherwise known as Affable Alfred. However, it's his period as Attorney General, and more particularly the advices he and his immediate successor, James Drake, gave to the government of the day, that I propose to examine this evening. And my purpose in doing so stems largely from an interest in history, and to that extent I'm being very self-indulgent. But I also thought it would be interesting to consider the issues that arose in those first few years after Federation, and to briefly compare them with the issues which we are currently dealing with today. And I would suggest that an understanding of the legal issues that confronted the new Federation is not only important historically and jurisprudentially, but to the extent that the issues have remained the same, it might give us pause to consider the impact of the answers provided then and those provided now in what is currently, I think, an active period of constitutional and administrative law jurisprudence. Deakin gave just over 157 opinions during his 30 months as Attorney General. Perhaps should divert to say that the opinions he gave were short and succinct, and perhaps were a little like that brief period a few years ago in the High Court where we were getting very brief and succinct decisions. But that's an aside. The topics upon which Deakin advised ranged widely. Questions of customs and excise arose frequently. His very first opinion, given on the 15th of March 1901, involved the question whether the collector of customs was required to pay into the Commonwealth Treasury fees that had been collected by the New South Wales Department of Customs and Excise. And it also examined the power of the Commonwealth and the states to levy customs and excise duties. And that was really reflective of the changeover period between the colonies imposing their own excises and duties and the Commonwealth taking those over. His second opinion related to the position of the Commonwealth and the states in respect of treaties that had been acceded to by the former colonies prior to Federation. And treaties with Honduras and Japan and a number of conventions with the United States were an issue. The latter two, that is, the treaty with Japan and the conventions with the United States, dealt with the disposal of estates of deceased persons. However, one might ponder what likely relationship the colonies had with Honduras at all, let alone to be worthy of a treaty. But again, that's a matter of history, because the treaty under consideration was not an Australian treaty, but the British Treaty of Friendship, Commerce and Navigation with Honduras. And that's the way that the colonies had engaged in treaties, that they acceded to the British treaties of the time if they were a nominated entity to do so. And what was the importance of Honduras? Not, so far as I know, so much to Australia, but to Britain. Honduras was a source of timber for the British. And when you're thinking that we're talking about friendship, commerce, timber and navigation, it may explain why the colonies would have acceded to it. Whether we had trade with Honduras, I haven't been able to find out, and the treaties themselves didn't provide any answer. Now, Deakin's approach in that opinion was legally pragmatic. He considered that the state should be able to continue to operate under the colonial treaties. And his opinion also expressed a founding father's vision for the new federation, as well as taking a quite literal approach to the interpretation of the Constitution. Noting that the Commonwealth had no express treaty-making power under the Constitution, he nonetheless considered that for the future, all treaties should be examined by the Commonwealth. And at that stage, he saw those treaties being the treaties of the British government. But he said, in terms of his vision for this new federation, that the Commonwealth must speak and act for the whole of the people over the whole of its territory, so that the imperial government, the British government, should extend to the Commonwealth the option of adherence to treaties that it had entered into, as it had hitherto done for the colonies. And in the same opinion, Deakin referred to the executive power of the new Commonwealth. For Deakin, the prism through which the new Commonwealth should conduct itself for the whole of the people was by the enactment of legislation that would allow the executive to administer all existing state laws that affected the nation as a Commonwealth, including naturalisation and aliens, I quote, special laws for the people of any race, migration, and of course treaties, conventions, and other matters of external affairs. And as he said, and I quote, the whole spirit and scope of the Constitution require that, save for the purposes of their domestic policies with their own domains, the states should be blended and absorbed into one political entity. This, for me, had the refrain of the jurisprudential concept of one common law for the whole of Australia that the High Court referred to in the Longy decision. But when you read that and you actually go to the footnotes, you understand that this concept of the one common law for Australia is sourced at least back to a couple of cases in 1936, when there was a reference to one system of jurisprudence, something that I hadn't previously realised. Although the intent of this paper is to compare and contrast the jurisprudence at the beginning of the 20th and the 21st century, it's worth noting that executive power and the reach of the external affairs power have often been handholders, and in respect of big Australian issues. Thus, in the Tasmanian Dam case, Chief Justice Gibbs observed that whether Australia enters into any particular international agreement was entirely a matter for the executive. Section 61 and the extent of the executive power had a revival in the Pape and the William cases in the High Court. The constitutional importance of those cases, their sociological consequences, and the implications for the rule of law are aligned. Except in cases of national emergency, the executive's power to appropriate and spend money must be founded in constitutionally supported legislation. In that regard, the Section 51(39) incidental power of the executive to expend and contract is of itself insufficient. Deakin's last opinion, his 157th opinion, related to absentee voting, which he advised was permissible under the Commonwealth Electoral Act of 1902. Voting rights again was an issue in 2010 in Roe and the Electoral Commission. Again, a case I'm sure you will all remember. Now, there are undoubtedly views as to which were the most important of Deakin's advices, just as to what are the seminal decisions of the High Court this century. But without entering into that debate, I have chosen 5 issues that have remained topical this century, albeit in different contexts: Indigenous Australians, tobacco, immigration, Chapter 3 courts, and the qualification requirements for members of Parliament. Time constraints this evening require that within that selection, the advices and decisions to which I refer will be very narrowly focused. But I trust that this brief excursus will at least heighten your natural thirst for Australian legal history. The relationship between the newly formed Commonwealth and Indigenous Australians arose in Deakin's 9th opinion, given on the 21st of August 1901. The questions raised in the 9th opinion were these: whether an excise duty may differentiate between sugar grown by black labour and sugar grown by white labour, And 2, whether a bounty may be given on the production of white-grown sugar only. The constitutional provisions involved included sections 51, 2 and 3, relating to taxation and bounties respectively, neither of which was, under the wording of the Constitution, to have a discriminatory effect. The answers to those questions were no to the first and yes to the second. Excise duties could not differentiate between sugar grown by black or white labour. However, a bounty could be given to white-grown sugar. The issue arose in the context where climatic conditions dictated where most sugar was grown, far north Queensland. Demographics, on the other hand, dictated the nature of the workforce, which in turn determined the cost of production. The black labour, as it was called, was centred or concentrated in the north, white labour in the south. So, adopting the language of the opinion, black labour was cheaper than white labour. There was thus a social and economic imperative, and almost undoubtedly a political imperative, to encourage employment for the white population. An excise would increase the cost of production and therefore, arguably, increase barriers to white employment, unless a lower and therefore discriminatory rate of excise applied in respect of sugar grown where labour was predominantly white, but that would be offensive to the Constitution. On the other hand, the payment of a bounty or a rebate, a provision for a rebate, was a means of alleviating the cost of production, thus providing incentives for employment in the south. So, having advised the Prime Minister that an unequal excise would be unconstitutional, but that bounties could be paid discriminately, the government introduced the Excise Tariff Act of 1902, which provided for a rebate to sugarcane producers who employed white labour only. The issue remained topical. In opinion number 57, dated the 4th of April 1902, Deakin was asked by the Minister for Trade and Customs 4 questions. I won't read them all out, they're up there for you, but let us look at the answers to the first. Will the employment of Aborigines of Australia by any grower of cane prevent his claim for rebate being allowed? Yes, very simple. Aboriginal labour, at least we'd gone to Aboriginal and not black, labour cannot be considered white labour. What about the employment of persons of mixed blood? And in this quest I came across a word I had not come across before. I think we've all heard of half-castes, but I had not heard of a quadroon, a quarter caste, if you want to use that type of language. So, and there is the answer. As to persons of mixed race, quadroons may reasonably be considered as white labour. Persons in whom the blood of a coloured race predominates should not. What about half-castes? That was a quandary. They were on the borderline. But in view of the affirmative and restrictive language of the provision, I think that half-castes should be excluded. With the employment of one person, one only, operating the same way, yes. And for the final question, what is understood as being embraced by the legislation? Would a coloured person employing white labour only, being the owner of a plantation, be entitled to the rebate? Yes. Very legalistic. The provision applies to the labour employed, not to the employer of labour. But at least I suppose that was one small victory. In opinion number 13, dated the 29th of August 1901, Deakin was asked whether half-castes should be included in the census. The question was directed to section 127 of the Constitution, which provided that in reckoning the numbers of people of the Commonwealth or of a state or other part of the Commonwealth, Aboriginal natives shall not be counted. Deakin advised that the relevant rule of statutory construction of such a provision, which was not remedial, was that the provision should be construed strictly. Accordingly, half-castes were not Aboriginal natives within the meaning of the section and thus should be included in the census. This approach to construction had been applied by Robert Garran, the great constitutional lawyer, who was appointed the first Secretary of the Attorney General's Department in 1901 in relation to the maternity allowance of 1912. In opinion number 485, and this is a diversion out of Deakin's opinions, in opinion number 485 of the 3rd of January 1913, Garran was asked whether maternity allowances could be paid in certain circumstances in light of the fact that Section 6 of that Act, which excluded women who are Asiatic from those who were entitled to be paid a maternity allowance. So Garran advised that a person of wholly Asiatic blood was disqualified. However, as the legislation was beneficial legislation, a woman who would otherwise be considered of Asiatic race, depending upon whether Asiatic blood predominated. Bottom line, a woman who was half Asiatic would be entitled to the allowance. Section 127 of the Constitution was repealed in 1967. The 1967 constitutional referendum also led to the deletion of the reference to the Aboriginal race in Section 51(26). And in 1975, the Commonwealth enacted the Racial Discrimination Act, Section 10, which guaranteed that persons of a particular race, colour or national or ethnic origin enjoyed the same rights as persons of other races, colour or national or ethnic origin. Nonetheless, the constitutional status of Indigenous Australians remains of contemporary relevance. Section 25 of the Constitution provides that where a state law provides for all people of a particular race to be disenfranchised at the state level, people of that race shall not be counted in reckoning the number of members of each state for the purposes of lower house representation in the Commonwealth Parliament. It remains within the Constitution. Now, these remnants of a past era have come under recent consideration with the consideration surrounding Indigenous constitutional recognition. The 2012 report, prepared by the expert panel on constitutional recognition of Indigenous Australians, recommended the repeal of Section 25 and of Section 51(26), and for the insertion of 3 new sections into the Constitution. That is, the recognition of Indigenous peoples, the prohibition of racial discrimination, and the recognition of Indigenous languages as the original Australian languages. The report hasn't been acted upon, and this is a surmise, but I think the position probably is that report has been superseded by the call in the Uluru Statement from the Heart, one of the most beautifully written documents one could find, which has called for a constitutionally recognised representative body and movement towards a treaty. This is not a new debate, the call for a treaty. This proposal is, and I couldn't find it, but it's either the 6th or the 8th call for a treaty, one of which is written on bark, I think in the 1930s. And it is said that Australia remains the only Commonwealth nation not to have a treaty with its Indigenous peoples. There has been discussion of a treaty in Victoria, and I think that discussion is going on with other states. I don't give any opinion as to whether a treaty is the right way to go, but if you think that you have a report not acted upon in 2012, a call for treaty which has been going on for well over half a decade, that there is a need for some recognition in some form of Indigenous rights. And there was, of course, the tectonic shift in the recognition of the Indigenous rights in the Mabo case. But just as with the answer that was given on questions of excises and bounties in the 1900s, other issues always seem to arise. And I like to call this the lawyer's spawning syndrome. You know, come up with one answer and someone will find another problem. And in Akiba, and the Commonwealth of Australia, the High Court allowed an appeal. So Akiba was in 2013 in the High Court. The High Court allowed an appeal from the full federal court, which had held that successive fisheries legislation enacted by colonial, state and Commonwealth legislatures, which had conditioned the right to engage in commercial fishing on the possession of a licence, had extinguished native title rights to take fish and other aquatic life for commercial purposes. That was the full court's decision. The rights had been distinguished by the commercial fishing licences statutory regime. But in the High Court, the focus and the statutory focus was on the inconsistency of rights. And following the decision in Yanna and Eaton, Justices Hayne, Kiefel and Bell told us that the repeated statutory injunction that no commercial fishing without a licence was not and is not inconsistent with the continued existence of the relevant native title rights and interests. So there is always, it seems, a question. Wherever there is a legal solution, it's my surmise that lawyers will try and find another argument. And it's interesting, I think, even in questions of that type, that it takes 3 layers of decision-making for a decision to come out, and even then, in the High Court, not always a unanimous decision. So these are obviously difficult questions. The way that we approach them, I think, is difficult. The High Court in these issues has stayed, I think, quite clear of policy, having got beyond Mabo, and has gone strongly in the area of statutory construction. Now, you might have thought that tobacco might be an unusual issue to raise in this review, particularly as no one is supposed to smoke anymore. But, you know, in 1900, it was rather interesting, 1904. Privatisation of public enterprises these days is an established feature of modern fiscal policy. However, in the early years of federation, the question was nationalisation. And in opinion number 171 in March 1904, James Drake was asked by Senator Playford whether the Commonwealth had the power to establish the manufacture of tobacco, cigars and cigarettes, close all present establishments and prevent private persons in future manufacturing such articles, not so as to shut them down in the interests of health, but so as to nationalise them for the fiscal benefit of the government. Drake expressed agreement with an early opinion of Deakin's on a proposal for the Commonwealth to manufacture iron, in which Deakin expressed the view that there was no express or implied source of power in Section 51 that would allow the Commonwealth to manufacture iron, except to the extent that the Commonwealth was doing so for its own purposes. And expressing agreement with that opinion, Drake observed that it was not easy to conceive how the manufacture of tobacco, cigars and cigarettes can be incidental to the execution of any of the express legislative powers of the Commonwealth. Interesting in itself, but interesting that there was even a reference in those early opinions to implied powers of the Commonwealth. Recently, tobacco was again at the centre of constitutional debate. You'll remember that the tobacco companies, or a tobacco company, challenged the constitutional validity of the Commonwealth's Tobacco Plain Packaging Act of 2011, in which the Commonwealth enacted pursuant to the External Affairs power, as well as the Corporations, Trade, Commerce and the Territories power, just in case they were caught short on one or other of them. We all know the result of that. The High Court held that the Commonwealth had not acquired an interest or benefit of a proprietary nature under the plain packaging scheme, which was necessary for there to be an acquisition of property for the purposes of Section 5131. There was a sequel to that. Philip Morris brought proceedings in the Permanent Court of Arbitration on the basis that the plain packaging legislation was in breach of a 1993 bilateral investment treaty between Australia and Hong Kong that included foreign investment protections. Philip Morris, of course, relocated to Hong Kong to take advantage of the treaty. And after a closed hearing in 2015, the challenge was rejected by the Permanent Court of Arbitration on the basis that the tribunal didn't have jurisdiction to hear the proceedings as they were an abuse of rights. But there were a couple of other tobacco cases. In fact, there's been a lot of tobacco cases. To the fiscal consternation of the New South Wales government in 1997, an additional fee imposed on the sale of tobacco as part of its licensing regime was held to be an excise tax on goods within Section 90 and therefore beyond the competency of the state legislature. I know from people within the Crown Solicitor's office at that time they were gobsmacked, to say nothing of the Treasury. But that case also spawned further litigation in which the retailers who had paid the fee to the wholesalers for the purposes of being collected successfully recovered that fee on the restitutionary basis of money paid under a mistake of fact, the mistake of fact being that the legislation was valid when in fact it was invalid. And they were able to recover it, notwithstanding that the retailers had passed that fee on to consumers. And I must say, the thought crossed my mind that at the end of the second decade of this century, I would have felt a class action coming on with a litigation funder lurking in what remaining smoking rooms there are to bring a case on behalf of the consumers who would want to claw back their 35 cents that they paid additionally on every packet of cigarettes they bought. It hasn't happened. Let's hope it doesn't. Immigration. Immigration, I suppose, being an island, being a place where people from overseas have been coming since 1788 and have continued to come, it's not surprising that immigration has been a constant throughout the jurisprudential history of this country. In the early years of the Commonwealth, questions ranged from whether deserters from British ships could be treated as prohibited immigrants under the Immigration Restriction Act of 1901, through to the meaning of descent in the phrase persons of European race or descent. The issues of the 21st century include questions such as whether the detention of a stateless person was authorised and required by the Migration Act, even though the removal from Australia was not reasonably practicable in the foreseeable future, as well as questions such as whether the Malaysian solution was valid under the Migration Act of 1958. I'll restrict myself to the first of those questions, whether a detention of a stateless person was authorised, and this, of course, is the Al-Kateb litigation. The answer in that case was the detention of a stateless person was authorised and required by the Migration Act. Although in that case, I've always considered that the dissenting decision of Chief Justice Gleeson to be a powerful statement of the principle of legality, but which also underscored the importance of basic human rights. And I'll only read the last sentence of that quote. The first paragraph, of course, is a classic statement of the principle of legality. But Chief Justice Gleeson said, "In a free society, under the rule of law, it is an expression of a legal value, respected by the courts and acknowledged by the courts to be respected by Parliament. That is the fundamental right for a person not to be imprisoned indefinitely without charge." And it seems to me that in Australia, in the absence of a Charter of Rights at a Commonwealth level, Chief Justice Gleeson's statements reinforces for us that we recognise jurisprudentially that there are certain basic human rights which exist and which can be legally recognised. And also as importantly, this significantly impacted, in His Honour's view, as to the proper approach to construction of the legislation. And Justice Gummow, of course, was in agreement with him. Justice Gummow led the charge on Chapter 3, jurisprudence. Now, the position of state courts also was an issue that arose in the early opinions of Deakin. In opinion number 20, in October of 1901, Deakin was asked about the source and nature of federal jurisdiction of state courts in relation to the Property for Public Purposes Acquisition Act. That Act provided that until the establishment of the High Court, all proceedings authorised to be taken in the High Court may be taken in the Supreme Court of a state, which would exercise all of the powers vested in the High Court. And there was a question as to whether the state judges had to be specifically nominated in order to be able to determine those questions, and his advice was that that was not necessary. But it was again the position of the courts and the jurisdictions of the court. The Commonwealth's power under Section 77(3) to make laws investing any court of a state with federal jurisdiction and the implications for Chapter 3 fairly much lay dormant after the Boilermakers case until the decision of the High Court in Cable and the Director of Public Prosecutions of New South Wales. I think we're all familiar with the Cable Doctrine, but whether we're as familiar with the actual legislation itself is interesting, because that was a legislation that was enacted purely to keep Mr. Cable in jail and nobody else. And the Community Protection Act of 1994 empowered the Supreme Court to order that a specified person be detained in prison for a specified period. But within the objects of the Act, Mr. Cable was the specified person, so it was an act directed to him only. Now, the court had to be satisfied to be able to make that order that there were reasonable grounds that the person is more likely than not to commit a serious act of violence, and that it is appropriate for the protection of a particular person or persons of the community generally, that the person be held in custody. Now, that is language with which we are all too familiar these days. But the difference was that the High Court took the view that the way that the legislation was framed, not only in terms of one individual, but the reference to the court may, if satisfied of those two things, was a mandatory provision and had to be read shall. So, in effect, the court was stripped of its discretionary power to make any determination upon satisfaction of two conditions. There were other problems, of course. The evidence upon which it could act was not evidence that would be admitted in the ordinary course in accordance with the principles of evidentiary admissibility and the like. So it was non-discretionary, based on inadmissible evidence, and a mandatory decision after a couple of conditions had been satisfied. And that act was held to be constitutionally invalid because it conferred non-judicial functions on the Supreme Court that were repugnant to its exercise of Commonwealth judicial power. And at the heart of the determination, of course, were the limitations imposed by Chapter 3 of the Constitution. And Justice Gaudron, in that case, observed that Chapter 3 requires that the Parliament of the States not legislate to confer powers on state courts which are repugnant to or incompatible with their exercise of the judicial power of the Commonwealth. And this was explained again a couple of years later in Baker and the Queen in the High Court, where it was said that the doctrine in Cable is expressed to be protective of the institutional integrity of the state courts as recipients and potential recipients of federal jurisdiction. And I think it's that phrase, protective of the institutional integrity of the state courts, which I think is again one of the great jurisprudential statements of this century. The High Court's Chapter 3 jurisprudence is further exemplified in Kirk. Now, one of the issues before the High Court in Kirk was the validity of a privative clause, which provided that a decision of the Industrial Court of New South Wales is final and may not be appealed against, reviewed, quashed or called into question by any court or tribunal. And in that case, the plurality observed that to deprive a state Supreme Court of its supervisory jurisdiction, enforcing the limits on the exercise of state executive and judicial power by persons and bodies other than that court would be to create islands of power immune from supervision and restraint. And again, a tremendous understanding of the nature of the separation of powers and the way that the separation of powers operates at a state sphere without a strict doctrine thereof, but always protecting the integrity of the courts. And then, of course, there were questions of qualification of members of Parliament. One of the very early advices given by Deakin concerned the issue of a member of the House of Representatives who hadn't been properly sworn in. Deakin advised that although Section 42 of the Constitution provided that every senator and every House member and every member of the House of Representatives shall, before taking his seat, her seat, make and subscribe an oath or affirmation in the form set forth in the schedule to the Constitution, this was a statutory direction, and it was not a condition precedent to a valid appointment to sit in Parliament. The importance, of course, for the senator concerned was that his right to his parliamentary allowance was preserved. In 1904, another question arose regarding parliamentary allowances. It concerned an elected member to the House of Representatives in an election that was declared void. And the question that was referred to James Drake as Attorney General on that occasion was whether the member was required to repay his allowance. And Drake advised, again in perfect understanding of the principles of restitution, Drake advised that he was bound to repay the amount which had been paid to him under a mistake of fact, the mistake of fact being as to the validity of the election. Then that member was dissatisfied, and just under 2 months later, when Henry Higgins succeeded Drake, the question was raised again. Higgins affirmed Drake's advice, noting that the position could have been, but had not been, altered by legislation. Another advice concerned a question of the residence requirements of members of Parliament, so getting a little closer to some of the more recent issues. Now, Section 34 of the Constitution provides that members of the House of Representatives must have been for 3 years at the least a resident within the limits of the Commonwealth. And in 1906, the following question was referred to the Attorney General, who was then Isaac Isaacs. So this is a classic, this is a classic constitutional law student's question, I think. So a candidate born in the Commonwealth, had resided here for 15 years, goes to a foreign country, or anywhere outside of the Commonwealth for that matter, I don't know what that meant, and returns after a lapse of 15 years and has only been a resident for 1 year. Is he qualified to nominate, or must he be resident for 3 years after he returns? And Isaac advised that Section 34 simply requires that one have been a resident for at least 3 years over any distributive period. And if the candidate has been at any time so resident, subsequent absence from the Commonwealth for any length of time does not affect his qualification. And during that period, other advices concerned whether qualification for election as a senator or a member of the House of Representatives extends to a state or division other than that in which the person resides, and whether the Commonwealth can disqualify members of state parliaments from election to Commonwealth parliaments. the answer being yes to both of those questions. And then came 2017, when questions relating to the qualification of persons to be members of Parliament kept the media as well as the High Court very busy. The media portrayed it as a circus. The High Court saw it as a matter of the proper construction of Section 44 of the Constitution. The downfall for members of that construction of Section 44(1) was the second limb, which provides an objective criterion and does not look at whether or not the candidate was minded to act upon a duty of allegiance to another country. That position had largely been set in Sykes and Cleary. But the transcript of the proceedings in Senator Cavanagh's case reveals that much of the argument revolved around whether a person was involuntarily a foreign subject. Now, I think we're all very familiar with this story. The senator, at the time the senator was born, his maternal grandfather had already lost his Italian citizenship and had been naturalised as an Australian citizen. Italian citizenship had traditionally passed down the male line. However, the Italian law had changed on the basis that it was discriminatory to limit citizenship to descent through the male line. And as a result, Senator Cavanagh's mother and Senator Cavanagh himself had become Italian citizens. And David Bennett QC's argument to the High Court that Senator Cavanagh, at the age of 2, did not have an understanding of Italian constitutional law fell on deaf ears. As the court explained, the disqualifying condition, citizenship of a foreign power, is identified by reference to the position under the domestic law of the relevant foreign country, and Senator Canavan was out. Now, whether a provision such as Section 44(1) continues to be desirable in a multicultural nation such as ours is beyond the scope of this paper. It's beyond the scope of the High Court's task, constitutional construction task in that case. But I think it is nevertheless perhaps an interesting question to consider. I don't think that the answer would necessarily be yes, and it might be one of those things where in a current climate, one doesn't know. We feel that allegiance to this country and the sole allegiance to this country is the way to go. I'll make another comment though, shortly about what I see the real significance of the Section 44(1) issues. Then, of course, there was Re Cullerton, number 2, where the court considered the question whether a senator had been validly elected in circumstances where prior to his nomination he'd been convicted in absentia of larceny, an offence which carried a term of imprisonment of up to 2 years. The offence, I think, related to some car keys, but did it fall within a class of cases contemplated by Section 44(2), which provides that any person convicted of an offence carrying a term of imprisonment of 1 year or longer is disqualified from election. Now, that conviction was later annulled, but the court nevertheless held that he was incapable of being chosen as a senator due to the fact that, as at the date of the election, he was a convicted person. But again, Section 44(2), I think, raises very important sociological questions. Do we have a concept of rehabilitation, for example, within the framework, sociological framework, so the persons who are convicted and have been convicted should forever be disqualified from public office. And then, of course, we had Re Day, Section 44(5), which is the pecuniary interest provision. And the court rejected the submission that it was only a legally enforceable interest that fell within Section 44(5), and again held that he was incapable of being chosen as a candidate for election. And that, again, very significant consequences for those who wish to stand for public office in this country. So this has been, as I said, a fly-through zone, a butterfly flit. But I think it's interesting to ask ourselves whether any conclusions can be drawn from what is a very, very selective consideration of the issues that arose 100 years ago and which continue to arise then. I mean, one could merely adopt the adage that history repeats itself and that legal history has the same cloning capacity as all history. But I would suggest, however, that there is a greater importance both in the synergy between the issues at the commencement of each century and in the outcomes. And I will mention 4 conclusions only, being those that obviously present themselves from the issues that I've raised. The first is an observation as to the extent to which commerce has changed, and what we will see in this country in the next decade is the increasing emphasis, I believe, on intellectual property as opposed to issues relating to tangible property. And the tobacco case is one example of that. I think the human genome case is another. The second conclusion is the underlying current of human rights in some decisions of the High Court. Now, some may consider that that particular observation is heretical, and indeed the trend may be subliminal. But I cite the Malaysian solution case and El Kadeb as examples. And I think the entire underlying basis of the recognition of Indigenous issues, where there has been a significant recognition that the rights of the post-1788 Australian population stand alongside those of Indigenous Australians, rather than Indigenous Australians having to fit a construct that is essentially European. Third, I would suggest that the Chapter 3 jurisprudence has provided an enormous safeguard to the rights of all citizens. And in this regard, it is apt to quote from the decision of the United States Supreme Court in Mistretta in the United States, which was cited by Justice Gummow in the Farden case. And that quote is this: that the reputation of the judicial branch of government may not be borrowed by the legislative and executive branches to cloak their work in the neutral colours of judicial action. An extraordinarily important statement as to the independence and the impartiality of the judiciary. And finally, the questions concerning the constitutional qualification requirements for members of Parliament raise these very important societal questions. As I've already mentioned, whether notwithstanding the diverse composition of our community, are there reasons for the retention of those qualifications, which of course extend beyond dual nationality and go to questions of whether we have a rehabilitative notion in our society and the way where do we stand on pecuniary interests. But for me, at the moment, the most important aspect of the Section 44 cases is that compliance with Section 44 for our politicians has at its base a central conception of the rule of law, that the law applies to all and is to be obeyed by all. Thank you.
There could have been no better way to commence Law Week than with Her Excellency's speech tonight. A skillful analysis and comparison of issues which were alive a century ago and still kicking today. We heard a sweeping survey commencing with Deakin's many opinions on race, some by Garron, through the 1967 referendum, the 2012 report, and then the Uluru Statement from the Heart. We had a quick puff on tobacco and its place in our constitutional history, especially on the vexed nature of excise. We heard of immigration, the cable doctrine in Chapter 3, and how better to end than with the issue of qualification of members of Parliament as we hurtle towards another election at the end of this week. We are grateful, Your Excellency, for the examination you've given to these matters and indeed your great generosity in coming here, a foreign colony, so early in this new chapter in your career. Would you please thank Her Excellency again? You are all welcome to join us for refreshments in the gallery outside, and would you now please rise for the departure of Her Excellency?
No, don't worry.
No, don't worry.
Let's all go.